Hello guys, good day. My name is Jeanette Odunye. I'm an entertainment lawyer and music publisher based in Lagos State, Nigeria. You're welcome back to my mini educational series where I talk about everything entertainment law, music publishing and the music business in general. So today I'm going to be talking about a very long overdue topic, and that is the important clauses you should be aware of, you should find in a music publishing agreement. So if you are a music publishing company or an individual that wants to sign artists, producers and composers to your company, or maybe you're a producer or composer and you are being offered a publishing deal, so these are the important clauses you are meant to look out for in a music publishing agreement. And now you're going to first you need to look at the term of the agreement. So you need to understand that there are different stages of terms and different periods in a music publishing agreement. So for example, now there is a contract period. The contract period is usually between 1 year or 12 months to 24 months or even more than, and that is like the term of the agreement, the number of years you and the publishing company have agreed to stick together and work together. That is a contract period. After the contract period, there's something called the options period. The option period is a period where the composer can grant the company the right to still represent them for a number of years or a number of months before they go their separate ways. And after the option period, there is a retention period. The retention period is a period where the publisher or the music publishing still has some rights over the compositions that was the subject of the publishing agreement during the term. This doesn't apply to any other song that was released after the contract period and the option period. Then after the retention period, we have the collection period. So the collection period is a number of years, a number of months where the company can be collecting royalties on the songs that were administered by the publishing company during the contract period, the options period, and the retention period. So once again, let me list out this period. So when they present you with a publishing agreement, you'll be like, oh no, they are trying to cheat me, or are they trying to play games with me? That why would there be so many periods? So you can understand how it works in music publishing. So there's a contract period. That's the period you and the publishing company have agreed to work together. There is the option period, which may or may not be compulsory. It's just the artist or the composer granting the company, and you guys can decide not to exercise the option period depending on your agreement. So you always need to get a lawyer to look into this to you. Then after the option period, there is a retention period, also known as a rights period. This is the period whereby the company has rights over the composition which were administered by the company during the publishing agreement, and it does not extend to songs that were released or songs that were worked on after the contract and option period. And there is a collection period that's the publisher still has the right to collect royalties for a number of years or number of months on the songs that were administered during the contract period, option period, and the retention period. But in every way, please make sure you always get a lawyer to read these terms to you. Then now we are going to go into royalties. So as regards royalties, it depends on the kind of agreement, the kind of publishing agreement that you, the composer, signs to the publishing company, or the publishing company intends to sign with the composer. So there are different types of publishing agreement. There is a co-publishing agreement, the full administration, traditional deal, publishing administrative agreement. There is the exclusive songwriting agreement. So basically, the royalties talks about or touches on the income that you and the publishing company have decided to share. So for co-publishing agreements, a co-publishing agreement is like a 50-50 publishing rights split between the publishing company and the composer. So normally it's between 60-40 or 50-50 that you and the publishing company would share. Any royalties that comes for your publishing will be shared equally with the publishing company. And for full traditional deals, that is where advance are always offer to the composer, and the company is hoping to get some recommend from the advance that was given to the composer and all. So it's usually between 80-20. I don't really know how that works. It just depends on the agreement. Then there's a publishing administrative agreement. So the percentage is usually between 10% to 25%, highest 30%, but it cannot be more than 30% for publishing administration agreements. Well, I'm not going to be explaining this kind of agreement to you because I don't want this to be like a legal advice kind of thing where people hold me by my words and refuse to get a lawyer when offers are offered to them. But at the same time, if you want an in-depth knowledge on this, I have a course on music publishing where you can get all the lowdown on all these things and all. So basically, like I said, royalties depends on the kind of agreement you are signing. So always talk to your lawyer and also confirm and be aware of the kind of publishing deal you are signing with the company before you sign anything. So you don't want a situation whereby they are offering you a publishing administration deal and they are saying they want to get 50% from your publishing or 40% for publishing. That is too excessive for a publishing administration agreement. So always get a lawyer to review. So another important clause is the rights. Once again, depending on the agreement, you need to be sure of the rights. There are different kind of agreements and each agreement has the kind of rights. So for publishing administration agreements, you do not assign your rights. You still own the rights to your publishing, but you are only giving the publishing company the license, aka the permission to help you to collect royalties and to remit royalties to you. That is what publishing administration do. Although a publishing administration can do other creative services like offering you sync, looking for sync for you, looking for gigs for you, but they are not bound to do all this additional things for you because you only give them the permission to collect royalties on your behalf and remit royalties to you. So you always have to manage your expectations when you sign a publishing admin deal. Although they are supposed to fight for split for you and make sure that you are getting your royalties on time and claiming your royalties, but that is all they are restricted to because they only give you the permission. But for traditional deals or exclusive songwriting agreements or co-publishing agreements, at this point you are going to be assigning your publishing right to the music publishing, so they will own your publishing right maybe forever or for a number of years. So then you don't have to manage your expectation because of course if you are making money from your works, they would also be making money from your works, and if they're giving you an advance, they are hoping to recoup from the advance given to you. So the kind of right that you'll be given to be assigning your rights and all, and also the agreement has to state the kind of right or the particular right that are being transferred. So for example, now for administration or any kind of agreement, it could be the right to reproduction, the right to adaptation, the right to performance, the right to allow other people or third parties to deal with your works, and the right to license your works to third parties. So another important clause is the accounting and audit clause. So basically this clause gives you the power and the right, the composer the power and the right to be able to go through the company's books and make sure that they are getting their correct royalties, or maybe if they are not paying the correct royalties. So basically the accounting clause, the company might require that whenever you want to audit or check their books, you have to send them a notice within maybe 30 days or 90 days or 3 months or whatever, and after that you need to get a qualified accountant to go through the books. But then some companies will insist that you get a auditor or a accountant from one of the big fours, and if you are going to be getting one of the accountants from the big four, you know that will be a lot of money. So once again, you need to get a lawyer to try to checkmate all these things that might make it impossible for you to be able to go through the publishing company's books. And also apart from that, the publishing company can also say that you can only review the accounts or go through their books within a number of years, and after a number of years, if you don't go through their books or request to go through their books, that means you've automatically accepted the royalties they've paid to you. And in case of an underpayment, they can say, okay, we would pay this sum to you, maybe with some incentive that they would repay the money you paid on getting an auditor and accountant to check their books. You get what I'm saying? So all these things you need to speak to your lawyer to make sure that you have been doing everything right. And the next one is termination clause. So in some agreements, termination clause, the company is only allowed to terminate. The composer is not allowed to terminate throughout the tenure of the publishing agreements. And this is a very dangerous clause that might not protect you as a composer, because if your publishing company is not representing you well, they are not chasing speed, they are not remitting royalties as a when due, you are stuck with them for life. And God help you if the contract period is 7 years and the retention period is 25 years, because yes, there are some retention periods that are 25 years and above. If I don't know about above, but there are retention periods that are as long as that. And if all these things are happening and you cannot terminate, my dear, you are stuck with them for life, except maybe a miracle happens and all of that. So make sure in the termination clause you are allowed to terminate. And again, some publishing companies can try to protect themselves that you cannot terminate within a number of months. Even irrespective of that, you also need to get a lawyer to negotiate. Even if you are going to agree to the number of months, it has to be something that favors you, and you understand. But all the same, termination is very important for you, because you don't want to be stuck in an agreement or in a contract where you are there for life and you don't know how to find your way out and all of that. So all in all, I would advise you, don't take my word for it. This is not proper legal advice. It's just pointers to getting a publishing deal, or pointers to how to navigate a publishing deal. But you must always get a lawyer to negotiate this kind of deals for you. Is very important. If you want to know more about music publishing contract, make sure you get my book on my course on music publishing. I'm going to be putting the link down below on this post for you to go and buy my course, and you're able to get more insight on what music publishing is, and music publishing agreements and all of that. So thank you guys for listening to my video. I hope to see you guys next time. Bye guys.